Hello, welcome to tutorial key points video 3 for W201. Now, with the bad weather that we had over the weekend, I know that most of you weren't able to make the tutorials, so for this occasion only, rather than just one key points video, I've actually made 4. And this first one is going to set out what the other ones are going to deal with, but also deal with some of the more general issues. The other videos, I'll be doing one specifically on TMAs and how to get the highest marks. I'm doing one on judicial review, and then finally one dedicated to TMAs 2 and 3. So this video summarises everything else that we dealt with in the tutorial itself. Press freedom obviously has been in the news a lot of late, and useful to read the arguments, critically evaluate those arguments, come to your own opinion on them, but do be thinking about the issues. TMA01, so I'll make some general points about TMAs later, but what I would warn against is the all I know about answer, which some people came up with in question 2, which describes and sets out the general principles of the law, and then in the last couple of paragraphs applies it to the problem question. Problem questions need to be structured to answer the question. You think of yourself, you've got an appointment with a solicitor, you're going to be paying an awful lot of money for their time. You don't want to sit there for 15-20 minutes being told the background to the law. You want an answer to your problem, and as you write your answers to problem questions, think of yourself in that position, wanting to know the precise answers to the problem, using background to explain, but focused on answering the question. Question 1, you were asked to evaluate these comments about the UK Constitution. Now, the key one, of course, was the unwritten nature. And, of course, unwritten has a specific meaning in this sense. And you needed to point out that it is written in lots of different places. But when we're talking about written and unwritten constitutions, we're talking about the single authoritative document. There were some very useful essays written setting out the sources. Again, that needed to be done, but briefly. The key point was the argument about how written or unwritten it was, where you'll find the written sources, perhaps a comparison of the value of those different sources. But it was a critical evaluation of unwritten that was necessary. Flexible, well, you needed to talk about entrenched provisions, that Dicey says that we can't have them, that perhaps we might be moving towards them as a result of the Thoburn case, which is beginning to recognise that there are a special set of constitutional laws that aren't going to be subject to the usual doctrine of implied repeal. But is it true of our system? Well, in that sense that there are very few barriers to changing the law. But look at some of the written constitutions that actually, in theory, are more rigid, but actually change more often than ours. And what conclusion you come to, I don't mind. But the recognition that of this paradox that rigid constitutions may turn out to be may change a lot, whereas our very flexible one actually doesn't change that much. Unitary. Well, the key point here is that power comes from the Westminster Parliament. Anything else is derived power. It gets its power because Parliament has given it. And of course Parliament could theoretically take it back. I'd like to see David Cameron take on the Scottish nationalists and say, no, we're taking it all back. I just wouldn't like to be in the way of the Scottish Army marching down on London to enforce their right. Separation of powers. Again, I didn't want a detailed description of what the doctrine is. I was looking for an assessment of how much it applied in the British system. And monarchical. Well, yes, we are a monarchy, but actually, are we a republic hidden behind the trappings of monarchy? A monarchy that really doesn't have any power, that is merely a figurehead. Now, I'm being a bit provocative in some of the things that I say about this, but do think about it, come to your own conclusions, and show your reasoning. The second question, Dicey needs to be applied, so do look at Dicey. You'll find him a useful friend for exam purposes because he was so good at giving memorable key points, usually 3 of them, for particular doctrines, and useful framework. The subject matter of future legislation, express and implied repeal, that's got to be dealt with. But central to this question was the manner and form argument. Can Parliament alter the future form of legislation? And you'll see in your manual that you've got reference to the thoughts of Marshall and Houston and De Smith. Well, weigh them up. Do you agree with them? The Parliament Act could be used as an argument to show that, yes, Parliament has changed the rules for recognition in these particular circumstances. So if it can do it for the Parliament Acts, why can't it do it for other things? The Trethowan case needs to be discussed. I'd urge you to read it. I'd urge you to again, for revision purposes, to have a look at what various people have said about it. And again, I was looking in your answer for a discussion about what was the relevance of Trethowan to UK 21st century. It's only a persuasive authority. Is it likely to be taken on board by the judges? And the final issue, would the courts review for compliance? Something that the Bill of Rights Act would seem to suggest they can't, but there are other cases that suggest that in certain circumstances they may be prepared to review. Bring in the cases. The topics that you're going to be looking at in the next few weeks are principles of civil liberties, and I want you to think hard about the merits and the weaknesses of the different approaches. Of the traditional English approach of you are free to do whatever you want as long as it's not illegal. Weigh up the strengths and weaknesses, see how much it's a product of its own time. By the end of the 17th century, we resolved most of these issues in the UK. It's in the 18th century that you get the USA and France taking an approach where a Bill of Rights, which talks about individual rights and protects them, is dealt with. There's the lessons learnt from the 20th centuries, the human capacity for evil, which was exposed in Nazi Germany and Soviet Russia, even in the last decade in former Yugoslavia. And the change in the nature of the state from a sort of hands-off approach by the state to a state which is very much involved in every aspect of our life. Make sure that you know the key provisions of the European Convention on Human Rights and of the Human Rights Act itself. Know the background, who wrote it, why it includes what it does, and the history of Britain's involvement on it, from inception through to allowing British citizens to take cases to Strasbourg, to the Human Rights Act. Know the key provisions and the topic subjects, protection of the person, freedom of property. They're in your manuals. Make sure that you know them thoroughly. Then we looked at freedom of expression and assembly. Again, look through the chapter headings on that, the restrictions on freedom of expression, the issue of press freedom, the way that obscenity law does restrict what we can publish, and public order. So make sure that you understand the framework for those areas. Privacy is key issue. The balancing between Article 8 and Article 10, and the cases of Campbell, involving Naomi Campbell, the model, and Murray, which J.K. Rowling's son, and his privacy. But that one is an area to look at in greater detail. And then we spent some time on judicial review, but I'm going to do a separate video on that. So thank you for your time.